it please the court, Richard May appearing for the appellee and petitioner for review, Dante Patterson. Excuse me. Mr. Chief Justice, I'd ask to reserve 3 minutes of my time for rebuttal.
3 minutes is granted.
Your Honors, the issue in this case simply, does a warrant to search a house, and a house alone, give police the right to search any vehicle they find in the driveway of that home? The Court of Appeals says yes, contrary to the district court.
Counsel, let me interrupt you there. Is that what the warrant said?
I'm sorry?
Is that what the warrant said?
The warrant?
That the warrant told the law enforcement you can search this home?
Yes. The warrant strictly was limited to the home, to the premises.
Okay, but isn't that different, though? Isn't premises different from home?
Well, under the case law, it's clear that we consider premises the home, the privilege of the home.
I just wanted to clarify that. You started your argument saying the warrant was limited to the home, and that's not my understanding.
Okay. Well, the premises, as has traditionally been held, includes the curtilage of the home. But it has not been held to include vehicles or persons. In fact, the warrant itself, at the end of the warrant, said you're commanded to search the above-named premises, conveyances, or people. And no conveyances or people were named. So the police get to the residence. Some of the officers go inside the house. Another officer, Officer Crow, immediately goes to the Mercedes in the driveway without knowing whose it is and begins searching based on, as his testimony was, on the authority of the warrant. That was the officer's testimony.
What did the records show? Wasn't there was a child sitting in the car?
There was a 14-year-old male sitting in the car, yes.
And that person told the officer that the car belonged to his dad, right?
Yes.
And the dad was named in the warrant?
I'm sorry.
The father was?
No person was named in the warrant, Your Honor. He was mentioned in the application, as were the other residents.
The application.
Right. I think actually the juvenile...
Before you go any further
Yes.
on that, I wondered if you could spend a minute and give the facts of this case so our audience knows what was found. I know we've been talking about the legal issues here, but if you could give a little bit of background, that'd be very helpful.
Certainly. When the house was searched, basically nothing of evidentiary value was found. There was, the officers testified, there was enough marijuana residue that perhaps you could roll one joint. So the warrant itself for the house was a bust. In the car was found cocaine and other manufacturing or drug-related paraphernalia. And it was in clothing, in a basket inside the car. And really the proceedings here, the case here is proceeding against my client based on what was found in the car, although on the grounds relates to the houses as well, some casualties. The Court of Appeals, in reaching its decision in this case, relied basically on the curtilage argument, which is not, in the Court of Appeals, and I certainly heard this part of their argument, or their opinion, was that this is a novel question in Kansas, with the exception of one case, State versus Coker. And in the Coker case, in 2003, another panel of the Court of Appeals found clearly that a visitor's car in a driveway, when search warrants are being executed, does not give the police the right to search that vehicle.
The factual distinction is pretty compelling. It was parked in between the house to be searched and a business that had public parking.
Right, there was a driveway between the two.
Right, and so it was parked in a position that was between the public, access to the public, and the private drive. And the other distinction, I believe, did that warrant mention vehicles?
It says they can search any vehicle they came across. And I would say, Your Honor, of course, Your Honor was on the Coker case. The difference there is it's really a difference without any kind of real difference. If you say, don't mention any cars, or mention all cars, it's the same problem. The requirement is specificity of the statute, and of course, the constitutional provisions, but the statute 225202 requires specificity for the search of persons, places, or vehicles, conveyances. And that wasn't included either in the Coker search warrant or the search warrant here. There was no specificity. Indeed, if the court or the state, the prosecution, believed that my client's car was of significance, they could have gotten a warrant for his car, found out what car he was driving, searched it. But again, as the facts proved in this case, Mr. Patterson was not a resident of the house. He was a visitor, visiting his son. His son lived with his son's mother at that residence. So any more than any other resident. But we look at the line of case law, we look at Ybarra. The United States Supreme Court has been clear that just being present when a search warrant is executed does not give police the right to search. We cited, besides Coker, which we think is significant, cases from other jurisdictions have held the same relating to vehicles. In fact, Justice Johnson in Coker, your panel there wrote, therefore, the concept of curtilage should not function to bootstrap the search of a visitor's vehicle by that portion of the search warrant which describes a residence. That's the case here. I understand the difference, but in the Coker case, both the residence and the business were being searched. There was a search warrant that included both the residence and the business. The driveway was in between the two. And the person who arrived was the mother-in-law, and her vehicle was searched.
Is there any question that you have that the vehicle was not within the curtilage of this particular premises that was?
Well, it's an interesting question.
Well, yeah, what's your answer that it was not? It seems to me that a car, a vehicle that is backed up to the garage, within 2 feet of the garage, satisfies the factors that we look at in determining what is within the curtilage and what isn't. Well, if this was a trash pull and they went up and took a trash pull, that means getting into the trash of someone's residence. We've kind of said something out near the street, not within the curtilage, something maybe closer to the home is, and it's protected there. So where's this particular vehicle at?
The vehicle is in the driveway.
Within 2 feet of the attached garage,
Yes,
correct?
within a few feet.
Right.
But this driveway is a very short driveway. If you look at the photograph that was the exhibit here, the front of the car was basically at the end of the driveway. And it's interesting you mentioned a trash pull because they had gotten the warrant in this case from doing trash pulls, and they described the location in the application of where the trash was about 3 feet or so where from the front of that where that front of the vehicle would be. So it's a very fine line of curtilage, if you will.
It's a perversity of the case, too, because usually curtilage is being invoked to talk about the area of privacy that can't be invaded without a warrant, not the area that you can invade because you have one. It's the flip side.
It certainly is.
Which makes me wonder if curtilage is even the right term for what we're trying to figure out.
And I think the Coker case would tell you no, and the cases we cited from Texas and Federal District Court from Arkansas would tell you no. Basurdo, which is sort of the key curtilage case, as we know, only talks about property. Curtilage as being property. We don't talk about people or automobiles as part of the curtilage because they move. That's the whole point. Now, this car had been in the garage. That may be another argument. But this car was out of the garage where a visitor would park. If you're visiting this house, there's basically one space for one car in that driveway.
Is that the distinction you would draw if comparing this to any other container that might have curtilage? Is mobility, is that?
Well, it's not a permanent part. When you talk about curtilage, you talk about property.
But what if this was just kind of a bunch of stuff that was leaning up against that garage? Almost a lean-to shed type.
Well, I understand, and shed would apply to Reserta, which would say, yes, that's part of the curtilage. But a car, especially a visitor's car, this was a visitor's car, comes and goes. People come and go. I don't think this court would say, well, the people were on the curtilage, so we could search them. The bar doesn't apply somehow, because we're going to say curtilage concept defeats that.
How clear is it that he was a visitor? I mean, wasn't in the trash pool, didn't they find utility statements in his name?
Well, the trash pulls were in September, one of the first ones, and then in November. The police said that there were articles that linked him to the house, but again, it was his son and his son's mother living there. But if you look at the record, when I questioned the motion to suppress, and this is volume 4, this would be about pages 50 to 51, did you find any documents there, mail, what have you, linking to my client? No, except the title to the Mercedes was in a drawer with some women's hair curlers and things of that nature, like a store. Did you find any male clothing, adult male clothing? No. They produced nothing to show that he was a resident. And in the preliminary hearing, which is volume 2 of the record you have, the police, in fact, testified in the preliminary hearing that he gave another address, and he was there just visiting his son.
The application in this case painted him as a resident.
Well, it did.
And you're not challenging, sorry.
I'm sorry,
What?
did or did not?
It did name him as a resident there. And yes, I am challenging that.
Have you challenged on appeal the reasonableness of the warrant itself? You're not challenging the issue of the warrant.
When we raised 2 motions, the court denied the reasonableness of the warrant based on probable cause. But the state has the burden of proving the validity of this search, the one that's
I
before the
understand,
court
but
now.
does the state bear the burden of proving the validity of the probable cause that supported the warrant when the state prevailed on that issue below?
Now, the argument was he a visitor or not? And the state, in fact, if you read the argument, counsel for the prosecution says, well, Mr. Ney hasn't put this on. Oh, well, it's actually our burden to show he was arrested. But there was questions about whether they found clothing, articles of mail, anything, which I asked the officer about. And they said they found nothing. And the previous testimony had been that he did not live there, as he testified.
You're not alleging here on appeal that that the state had no probable cause to support the warrant.
That's not the subject of this
Appeal, right.
appeal. In fact, it's the state's appeal.
Right, and the argument is over the scope of the warrant. Essentially, yeah.
Yes, but the Court of Appeals somehow tried to bootstrap or create this nexus between the defendant.
Well, counsel, and the reason that I can see that being relevant is if we are going to follow Justice Byers' suggestion that maybe curtilage is the incorrect legal rubric through which to view this case, it would seem to me we would fall back on the touchstone of Fourth Amendment law, which is simply reasonableness. And I guess the question to me, of mine to you then, is why wasn't this search simply reasonable, given the facts that the officers had at the time, which were that they submitted an affidavit that there was probable cause, that Mr. Patterson was a resident of the home, they find the vehicle parked up right next to the home, they obtain information that the vehicle belongs to Patterson. Why isn't that search reasonable, just like any other search of any other container on those premises would be reasonable?
Well, because the Fourth Amendment and the statutes in Kansas apply to a particular description of things to be searched. Could the officer have said, okay, now we've got a car here, but the search was going on before they knew the car belonged to Mr. Patterson. Eventually, they do have the conversation with the 14-year-old.
That goes back to my question, when did
Right.
that conversation occur?
I think it's unclear from the record.
Okay.
And the Court of Appeals,
The young man, child,
right.
teenager, was sitting in the car. So once they're searching it, presumably they have to either remove him from it or ask him to get out of it. There's a conversation occurring right then.
But the officer testified he was going to search the car based on the warrant, and he did. without any connection to that. And the Court of Appeals, I want to point out, at the best they could say, and this is from the last page of their opinion, says the way the car was in the driveway, the manner where it was parked, its nearness to the house, all suggested that the car belonged to a resident. I don't think that's sufficient. I don't think we can create a search warrant for premises and then say it applies to whatever we want it to once we're on the scene. And without the particularity that's required in the Fourth Amendment and the Kansas statute.
Counsel, I see you're out of time. Would you like 60 seconds to wrap up?
I will.
Make your point.
I'll reserve my time.
I do have one question. I'm still puzzled about that. I'm still puzzled about whether there is a legal difference between this being an automobile and whether this has been a closed trash can. The police looked inside the closed trash can.
Well, there is. And I think the difference is both under the Fourth Amendment, as I said, jurisprudence, but under 252302 names three things that a search warrant must describe in particularity: a place, a person, or a means of conveyance. It doesn't talk about trash cans. And I think we have, the case law has encompassed things like trash cans or sheds into the premises concept, the place concept. But it clearly is a distinction between conveyances, which can come and go. And I think that's the difference. Visitors do not come with their trash cans to someone's residence, but they do come with their cars.
So is that a statutory argument or a constitutional argument?
It's both. I think the statute here was a codification of constitutional concepts of what is a required particularity in description. So it's truly both.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
Good evening once again, Your Honor. My name is Lance Gillette, and I'm the Assistant District Attorney from Secretary County on behalf of the state appellant in this case. As a preliminary matter, the court may know I was not on the brief. I'm arguing this on behalf of one of my colleagues. I think that I would start off with just a general principle in this case, that what is it about this case that would necessitate a departure from decades, literally in this instance, decades of jurisprudence? And the answer is nothing. If we start with the line of cases that the state has cited in our brief with Basurdo, which was specifically adopted and affirmed by this court, a search warrant which described a specific residence to be searched authorizes the search of that residence and any other structures, buildings, or vehicles located within the curtilage. Their case law is replete with other examples, specifically from the 10th Circuit.
That case did involve a shed, didn't it?
Basurdo did indeed involve a shed.
So it's hard to put the reference to vehicles.
I think that there is some argument that can be made that it is dicta. However, I think that the general principle stands in that when a search warrant is granted, it is for the entire premises and all of the containers thereon. And that would include a shed. That would include vehicles.
How do you respond to counsel's argument about the language of the statute differentiating between places and conveyances?
I do believe that there is a reason for a distinction here, but I think that ultimately when it comes down to, in this case, is that it may be a distinction without a difference. When there's probable cause to search a location, and the fact that within that premises a car may be located, it's arguably reasonable to assume or to conclude that that vehicle may actually carry away evidence of a crime, or it could actually contain therein, could pose a danger to officers. And so, while there is a delineation made within the statute, I think that the case law itself properly interprets the intent and the merits as it regards to Fourth Amendment and the protection from unreasonable searches and seizures. I think that it is reasonable to search a car that is on the premises.
That argument does seem to go to a per se exception that would allow a search of any vehicle. And the case law certainly isn't that wrong. So I don't know that we can accept that as almost a exigency sort of circumstance that we create an exception.
And I don't mean to, and if I was unclear, I meant to indicate that a vehicle that is on the premises, and that premises, then we start to roll into our curtilage test, whether the vehicle is so closely associated with the home that it can be considered as part of the premises. For instance, I understand Your Honor's concern. We certainly would want to stop individuals from the community that would just happen to be driving by while these officers are executing a search warrant. Perhaps they're even curious and might stop across the street and attempt to watch.
Or if they stop in the driveway.
Well, then I think that you have a couple of issues there. And if I understand your question, are you asking whether or not I think that we could search their car?
Right. If you have a search warrant for the residential premises,
Right.
a stranger pulls in the driveway, say they're going to just back up, go the other way, and they are on the curtilage, that's sufficient nexus to the residents to allow that search.
It would depend on the interpretation and the specific facts of the curtilage. And I think that's...
I'm hearing you say that the curtilage includes vehicles that are contained within that boundary, within that area. Did I misunderstand you? That was sufficient, the naming of the premises is sufficient to include vehicles that fall within the parameter of the residence.
Within the premises, yes. My point in drawing a distinction here is not all driveways are the same. For instance, a rural driveway where you may have someone entering, quote-unquote, the premises a mile or so away from the actual home is obviously different.
Let's get away from that. Let's say it's a driveway which would be within the curtilage if it were a shed. Okay?
Sure. If they pulled up to that degree within the curtilage, then possibly is the best
Even
answer.
if they're just driving by. Even if they're just driving by. Because that really is a kind of a blanket exception.
Not if they're just driving by. If they drive in and pull all the way up to the house as though they live there, own the house, then possibly. The statute, I believe, do provide that individuals can be stopped during the execution of a warrant. Now, there are some questions that arise that are not relevant in this case as to whether the arrival during the execution of a warrant may create some exception there as well.
Let's deal with this case. We've got two cars, right?
Yes.
But from the photographs that are in the record, there's a car parked on the curb,
Correct.
and then there's a car in the driveway.
Correct.
You didn't search the one on the curb.
That is correct.
How come?
I wish I could answer that question because I believe that the probable cause plus exigent circumstances exception to the search warrant requirement may have and likely could have allowed the officers to search that car. Because as the court would note from the record in this case, both cars were actually owned by the defendant. And I have substantial dispute with my opposing counsel's description of the defendant as not a resident of his home.
Well, I want to focus on these two cars because it seems to me that's where part of the question here gets us. That I can't see why, and I don't want to talk about exigent circumstances because you guys are arguing that this came within the language of the search warrant. So stick to the language of the search warrant. Why one and not the other?
And my best answer to that question, Your Honor, is that the car that was parked on the street was on a public thoroughfare. It was not within the curtilage of the home. It would not have fallen within the scope of the
So are we talking about proximity to the house being the deciding factor? Or is there anything else that enters into the calculus?
There are, and that's where we get into the Dunn case. And proximity to the home is certainly a factor. Dunn case, United States versus Dunn from the United States Supreme Court identifies 4 factors that are generally recognized by this court as determinative of whether or not an object or an item, a container, is within the curtilage.
And let's take those 4 points. Do the officers have to know the answers to those 4 points before they search, or can they back it up later?
I'll be perfectly honest, that's a good question. That is one that I hadn't necessarily thought about. I think under either circumstance in this case, the 4 factors though weigh in favor of authorizing the search of the White Mercedes. The proximity to the area, as we've all discussed, this car was, and I think it's important as well, the car wasn't just pulled into the driveway, it was backed up into the driveway within feet of the home. Maybe enough room for a person to walk behind it. The photograph speaks for itself. There is a significant additional portion of the driveway for enough room for at least one more car. Furthermore, the location of this car was at the only point of ingress or egress to an attached garage, a 1-car attached garage. I think that is indicative of the fact that it's unlikely that a guest would park in this manner in that location. The second factor is whether that area is included within an enclosure surrounding the home. In the instant case, there was a fence, albeit without a gate. There was a fence. The car was within the fence line. If we were to extend that fence line across, the car is well within the fence line to the degree that the Court of Appeals noted that, quote, at the very least, this placement suggests that the car belongs to the household. Again, not the way a visitor or an innocent bystander may park. And I would just remind the court that the fence itself has meaning, and it's really twofold. It delineates an area even closer to the home over which that homeowner desires to associate with a higher level of privacy, and it also keeps people out of that area. So the fence does have significance here. The third Dunn factor was the nature and use to which the area is put. We're talking about the top of the driveway. This car is all but backed into the garage. Now, the cars, as we've talked about, they do transport people, obviously. They're mobile. However, cars also store items. I don't think it's beyond common sense to realize that we all store items in our cars and carry things in and out of them every day. They transport things to and from our homes. In this instance, the officers were searching for drugs. This was a narcotics search warrant. I believe it included firearms. Drugs move. They have to move somehow. They come and they go, as do their proceeds. And in this case, there was over $10,000 in cash alleged to have been drug proceeds stored in the master bedroom of his home where the defendant was located. But again, going back to the car, it's his car.
Do the officers know it's his car before they go in?
To that end, I don't know that they knew he owned the car. I think that it was very reasonable to conclude that the person that owned that car lived at the home. When they were approaching, they saw the defendant's son, and they identified him in the driver's seat, sitting in the car as they approached. They knew who that was. They knew it was the defendant's son. In fact, the son was removed from the car, and one other individual that was ultimately located in the basement of the home were all named in the application for search warrants. So this was very specific as to where and who we were looking for. Again,
If the law enforcement officers knew that this particular person was the target of their drug investigation or their drug search, and they have the capability to find out what vehicles are registered to that person, and as you said earlier, it's only common sense that drugs might be stored in the vehicle, then why isn't the remedy for law enforcement to take that next step and say the resident and this vehicle and this vehicle?
Are you asking if we should have named it specifically at the very beginning? I don't know that there's a reason couldn't have. It would have been, additional investigation certainly would have been necessary.
And I think that's what counsel's trying to argue, is that our fourth amendment jurisprudence is that you need to name with particularity what you intend to serve. That it doesn't give you carte blanche just to go willy-nilly do whatever you want. And that if they have the means to name that vehicle in the warrant, why is it reasonable to let them search it when they just didn't take that step to do it?
I don't know that I honestly don't know that they had the means in this particular case. And the other side of that is that we're talking about something that's happening very quickly. In this instance specifically, it was a no-knock warrant. Again, cars move. It may or may not have been there. They may or may not have been able to find the car, even if they had specified it in the warrant at the time. And the Fourth Amendment jurisprudence, actually, the state believes is fairly clear that a car on the premises can be searched, as with any other container on the premises, for which there's probable cause to search.
Counsel, are you going to go through the fourth and done factor before you sit down?
I will briefly address that. Thank you, Your Honor. The fourth factor are the steps taken by the resident to protect the area from observation by people passing by. Again, this car is backed and pulled all the way up to the house. And in order to have even gotten close to this car, you would have been ended up going up the driveway towards the garage and have been immediately next to the home. And I think that touches a little bit on what Justice Beyer pointed out. There's an interesting twist of the case in that he's not claiming privacy here. And the trash can analogy comes in again here as well. I think if the roles were reversed, if these officers had just gone up and started cruising around his car at the top of the driveway right next to his house, we would have seen a completely different search warrant. One where we would have been alleged to have invaded his curtilage and invaded his privacy, violated his rights. So there's a bit of a catch-22 here. And I also think it's interesting to note that just some of you have asked about the trash cans, when they're next to the house, they're given basically the same protection as the house. When they're by the curb, they receive a different level of protection. I see it similarly with a vehicle, which is traditionally under Fourth Amendment jurisprudence, given some of, if not the least amount of privacy of any container or item of person that personally owned. I see no reason in logic to treat that any differently than we would treat, or with any higher level of scrutiny than we would treat a shed or a trash can.
Does that mean that you would disagree with the next step that the Court of Appeals took, which was to apply the Tenth Circuit's decision in Gottschalk and require some showing of indicia of control or possession by the occupants of the premises over the vehicle?
I don't think that the Tenth Circuit's Gottschalk point of establishing ownership is necessarily unreasonable. I do not, though, see any reason to change what has been the standard practice in Kansas, as I mentioned before, for decades, which is if it's described, if the residence is specifically described as it was in this case, then a vehicle found on that premises can also be searched. In this case, though, as it did turn out, I think there's a strong argument to be made that ownership of the vehicle by a resident of the home was demonstrated, again, by those privilege factors, by the fact that the defendant's son was in the car, and ultimately, I don't think that we need to necessarily turn a blind eye to the fact that the title to the car with the defendant's name on it was found in the master bedroom, the same location where he was when officers entered the home.
But we don't know that that was found before they started the search of the car.
Unfortunately, we don't. We also don't know that it was found after. Unfortunately,
We just don't know, and we don't know exactly when the conversation with the child was. So,
Correct.
if I'm understanding your answer to my colleague's question, you're saying Gottschalk is nice but not necessary.
I think that's a fair way to characterize it. It's nice, but it is unnecessary.
So you lost this case at the district court level. The district court suppressed the evidence. You appeal. You have to stay. What's the rule of law that you want to come out of our decision?
The rule of law that the state would like to see come from this decision is that the rule of law remain as it stands. That vehicles that are within the premises can be searched when there's probable
Pursuant to
cause.
a warrant for the premises.
when there's a search warrant for the
And let me
premises.
just stop there for just one more second. And that is, you keep referring to this as a rule of law, but then a moment ago you referred to it as a practice. Is it a practice that we'd like to see a rule of law support, or are you actually telling us that the rule of law already does support it?
My apologies if I said that, I believe I misspoke. I believe that the rule of law is that if there is a search warrant, then a vehicle within the premises of that target location may be searched.
Notwithstanding the particularity requirement in the Fourth Amendment or the statute pointed out.
Correct. And for that, I would cite, again, back to Acerto, and I would also note, this court's opinion. The sentence was at 218 Can 750 and Timmons, and it reads, quote, "The automobile, comma, being parked in the driveway, comma, was on the premises." I think I'm even more deferential than that statement is, as far as my earlier hypothetical about the differences amongst driveways, but that statement is fairly clear, and I think that's part of our alternative argument for good faith exception, which we would also ask that this court consider this case.
So if you were hosting a party at your house and 4 cars parked in the driveway, you have a couple driveway, those vehicles would be subject to search regardless of their ownership.
I believe
If there was a warrant for the premises.
I believe that that would be reasonable, and that's the, I guess, ultimate measuring stick here is what we're talking about is the Fourth Amendment protecting individuals from unreasonable searches and seizures. Under those circumstances, when you've got probable cause to come search my house, then vehicles that are within my curtilage can be searched.
Why is it reasonable that the police will find fruits of a crime or whatever in my car simply because I go to a party at your house and the police have given the magistrate probable cause to believe that you have contraband? Why is it reasonable to believe my car has contraband?
I think the question of reasonableness is whether searching your car is reasonable, not necessarily whether they had probable cause to search your car, but whether a search of it, because it is on my premises for whom they do have probable cause, is reasonable. And I think that the balance has to weigh in favor of temporary seizure and a brief search of a vehicle.
And why do we hit the balance that way when the Constitution says the general rule is that you get a search warrant for particularity?
Because the particularity, and I know this comes right back to the beginning, the particularity was as to my premises, and within my premises, you have probable cause to search the home, any containers on that property. That would include Justice Johnson's vehicle, if you had gotten my bar.
Have you seen his vehicle?
I didn't see mine.
Any further questions?
One, counsel, what in your view is the purpose of the statutory listing of conveyances?
The purpose of listing it is separate item.
Well, why is that in the statute, given the rule that you articulated that you would like us to adopt?
Because I believe in different factual scenarios, there are instances where officers applying for a search warrant may only have probable cause to get into a vehicle. I can speak slightly outside the record, but in my experience in cases with DUI, collision, things like that, when we decide we want to search a vehicle or search the computer module from that vehicle, I don't have probable cause to go back and search the driver of that vehicle's home because there was an accident. I do have probable cause to search that vehicle specifically.
So you would interpret the statute as essentially listing a list with a list of things with specificity that can be searched in a sort of declining order of narrowness. With a premise, a home is wide, a vehicle is less wide, a person perhaps less wide.
I believe that is correct.
Any further questions? Thank you, counsel.
Thank you, Your Honor.
Reserve 3 minutes for rebuttal.
Let me first, Justice Breyer, answer a couple of questions you raised. One, it's only in the preliminary hearing transcript, not the motion transcript, where the statement is made that the teenager gave a statement about the ownership of the car. So however that goes. But we do have exact information about when the car title was found. Volume 4, page 53, I'm questioning the officer who found the title, and he says it was 34 minutes into the search. And even the Court of Appeals, in its opinion, says they found it during the search of the Mercedes or afterwards. So clearly, they did not have the title before they started the search of the car. The state says that jurisprudence says in Kansas you can search cars. I don't know that case. The only case even the Court of Appeals recognizes that is on that point is Coker, and Coker at least argues the opposite. And I think it's important to know we're looking at the issue of probable cause to search the car. The exigent circumstances, how you can proceed without a warrant for a vehicle, is based on probable cause.
And warrantless. You only go there if it's warrantless.
Right.
This is a warrant search.
And I think it's important, I want to take just a couple seconds of my time to read what Judge Burgess said at the time he made the suppression. He defined, he talked about this court definition of premise. It says the term premise as used in the warrant included all property necessarily a part of and appearing to be so inseparable as to be considered a portion thereof. Quoting from McClellan as to this court's definition of premises. He then goes on to say, well, obviously, taking that language and contrasting Baserto with the facts in this case, in Baserto there's a shed, that's an inseparable part of the premises. In this case, we've got an automobile. There's no separate probable cause with regard to that automobile. It is parked outside. It was occupied by the defendant's son. It is not included within the scope of this particular search warrant. He specifically says nothing gave probable cause to the search of the car. And if you look at the application for the warrant, it was based on trash pulls at the residence. And that's basically it alone and some unnamed informant. The point being is nothing in the application would say that the car or any vehicle had been used for anything. And finally, the state tries to resurrect good faith here. That's not something they argued in this motion. So we ask the court to reject that. If there are no further questions.
I'd like to ask you to help me understand your argument with respect to the statute. I understood you in your previous argument to say that the statutory listing of conveyances for vehicles was merely a codification of the constitutional protection that already existed. Is that right?
Well, I don't think merely, but I think that's true, yes. The state creating the statute was talking about what it's...
So it's your position that, as I understand it, that the Constitution requires any search of a vehicle pursuant to a warrant, it requires that warrant to describe the vehicle with specificity.
Yes.
Okay. And so
Well, again, let me give this exception. If it's in a garage, perhaps, and that's considered part of the premises, this was not.
Well, and now we're back to arguing about curtilage and so on.
I think curtilage is the absolute wrong thing to think of here. Because let's concede the car is on the curtilage. It's in the driveway. So what? People are on the curtilage. If 10 people are standing there in the yard behind that fence, and only the fence goes around the yard, do we say they can be searched? Well, your bar would say no. The U.S. Supreme Court and this court in Van Dyke are pretty clear on that. So curtilage doesn't get the state to where they want to be.
Okay, but it also doesn't get you where you want to be, which, as I understood it, was that there's a bright line rule going the other way. In other words, there's a bright line rule that any time you search a vehicle pursuant to a warrant, that vehicle better be described with particularity in the warrant. That's the bright line rule you're arguing for, as I understand.
Yes, it is. Unless something leads to probable cause to search that vehicle.
Which would be a search that was pursuant to some other rationale, not pursuant to the warrant.
Yes, and the officer's testimony here was very clear. We were searching the car pursuant to the
And
warrant.
so I guess my final follow-up seems to me your position is that the statute does not, in fact, provide any greater protections that are not afforded under the Constitution. In other words, they're coextensive.
I believe that's true, but certainly the statute says what it says with particularity to conveyance, describes conveyance.
Any further questions?
I'm confused, so if you can clarify, because I thought you started to say that there could be a difference for a vehicle that was in a garage, but then you said, no, we're not talking curtilage. Are you backing up so that we're not talking about a warrant covering a vehicle in a garage? You change your position on that?
I don't know that I changed my position. I think that's not a question we have before us here. So again, if I were here on that case, I might argue that the vehicle has to be described. But if it's an enclosed shed, if you will, or the garage or the like, then there might be a different argument the state could make. That the warrant for the premises, including what was contained in
The
In the premise.
in the house.
car
Which you're
is
defining.
container in the premises as opposed to.
Right, as a
conveyance.
right, opposed to a conveyance which is parked in the driveway.
And again, you're defining premises in that way as a building, not as the property, including land, located at whatever the street address is.
Right. I would suggest